whether there's law or not, responsible AI will require certain assessments, certain oversight, certain accountability within a company. Like our company should be doing this regardless of whether there's law in the books or not.
Hello! Welcome to the first BetaKit podcast episode of the new year. When we last podded, we were doing our 2022 review and 2023 predictions. A topic that came up in both? AI. Generative AI seems to be in the news almost daily right now, with reports that Microsoft is going to incorporate ChatGPT into Bing. OpenAI is looking to raise at a $29 billion valuation. Oh yeah, there's also the fact that school boards are looking to block generative tech in the vain hope that it won't completely disrupt our modern pedagogy before kids are back in school. It's probably a good time to note that what is also coming in 2023 is AI regulation. In some parts of the world, it's already here. In Canada, well, we must look to Bill C-27, which is currently making its way through a second reading. Now, what is Bill C-27? It's a bit of a legislative turducken. A bill duckin, if you will, containing multiple acts related to digital privacy, Canada's digital charter, and tightly wrapped in the warm center, an Artificial Intelligence and Data Act. Now, it's that act that has spawned a variety of constructive criticisms from all sides, saying it's too rushed, too harsh, too vague, and hasn't had enough expert consultation. Some are asking that ADA actually gets stripped out of Bill C-27 entirely. Speaking of experts, today on the podcast we have one Carole Piovesan, managing partner at INQ Law. Now, Carole has worked with the federal government on its position statement on artificial intelligence. She's served as a member of the Global Partnership on AI. She's an adjunct professor on AI regulation at the University of Toronto. And AI regulation is also a subject that she wrote a book about. Carole might not refer to Bill C-27 as a Bill Duckin, but that's part of the reason why we have her on the pod, for her expertise. One note, due to some technical difficulties, Carole had to switch microphones about halfway through the recording. She sounds great, just as insightful, just a little different towards the back end. Okay, for the first time in 2023, let's dig in. I'm wondering, first, if you could explain what Bill C-27 comprises in brief to set the stage for the conversation we're about to have.
Sure. So Bill C-27 is a three-part bill that includes major reform to Canada's federal private sector privacy law. So it would repeal and replace the Personal Information Electronic Documents Act. The second part of the bill would establish a new tribunal associated with Part 1, which is the reformed private sector privacy law. And then the third part of the bill introduces new regulation specific to artificial intelligence. So they're united in that they're specific around data and technology, like data-rich technology, but they are three parts of a bill.
Can you describe to me why you are an expert on this subject?
Yeah, I mean, listen, I've spent the last number of years, my training is as a litigator, as a civil litigator, but I use that to really look at the intersection between this really interesting technology and the law. Throughout the course of the last few years, I've been specifically focusing on the regulation of artificial intelligence and what does responsible AI look like? What does it mean? When you look at artificial intelligence as a technology and then the component parts that go into that technology, you necessarily have to look at the law that regulates data. And in Canada, the law that regulates data is regulating personal information. It doesn't regulate non-personal information. So this has been a culmination of playing different roles on the policy side, on the legal side, and then really practically, I'm very big about practical. So very practically, how do you operationalize all of these great ideas?
Okay, that's really important because I think where our audience comes into play on this is how this operationalizes. That tension between, I don't know if it's privacy and innovation or policy and innovation, but I think that they're all playing a role here. I'm wondering, even just before we dig into the Artificial Intelligence and Data Act, which is where we're going to spend, I think, most of our time talking today, how does all of this connect to Canada's digital charter? Because I know when C27 was introduced, Minister Champagne was speaking to the role that this bill will have with that. And I know that with the previous minister, Minister Baines, you actually consulted on the digital charter work.
So the digital charter was a few years in the making. It started with the 2018 consultations. At least my involvement with it started with the 2018 national consultations on digital and data transformation. And that established that it was a conversation with Canadians to help establish some of the key priorities. If you fast forward to 2019, out came a white paper on PIPEDA reform, as well as the digital charter that articulated 10 principles on the sort of Canada in the digital economy. So really what the digital charter was doing was articulating sort of Canada's position in terms of some of the key leading values for the digital economy at a very high level. Part of that process, because there was so much discussion about, what does Canada look like in a digital future? What does Canada look like moving away from our historic human natural resources economy to more of a digital economy? What does Canada of the future actually look like? So much of that had to do with, do our privacy laws hold up? Are we really advancing? We've always had very strong, very good privacy laws. Last 20, 22 years, we've had strong privacy laws. Are we well positioned to lead as a Canadian economy in the digital world? And so with that came a number of consultations looking at what's happening around the world, looking at where we have a competitive advantage, identifying the fact that AI was a huge competitive advantage for Canada. We were one of the first countries, in fact, we were the first country to have a national strategy on AI. We invested a lot in that national strategy through the Pan-Canadian strategy on artificial intelligence. We've seen a number of different investments through the superclusters made in artificial intelligence. We saw the Prime Minister Trudeau teaming up with France to articulate a priority around data and AI ethics, which ultimately led to the global partnership on AI. So Canada playing a really key role in a number of different areas when it comes to this very data-rich technology, which is artificial intelligence, or one of which is artificial intelligence. All of that leads to 2021, where we have Bill C-11 tabled, and that was specific to what you see now as Part 1 and 2 of Bill C-27.
Yes, and that bill did not make it.
That bill did not make it. We had an election, the bill died on the order paper, and it did not make it. It also did not include a specific part on artificial intelligence. So the AI and Data Act was nowhere to be found in Bill C-11. So cut to 2022, where Canada now tables Bill C-27. It includes Part 1 and Part 2 that we found under Bill C-11, which is specific to reforming, repealing, and replacing PIPEDA. But in this Bill C-27, it also adds the Artificial Intelligence and Data Act, which is apropos, given that we have seen the EU in April 2021 table pretty prescriptive, a pretty detailed draft EU Artificial Intelligence Act that would apply to high-risk AI systems brought into or developed in the EU. And we've seen something like 130 bills tabled in the US, all the way from cities straight through to the federal level. So you've got a lot of activity around the regulation of artificial intelligence. Some are sector specific, some are technology. They're regulating the technology itself, as you see under the EU AI Act. And Canada, in putting forward its draft bill, which is Part 3 of Bill C-27, it now articulated some very high-level principles to regulate high-impact AI systems. And you can see Canada taking a bit of a middle ground as between what we find at the federal level, in particular in the US, and then in the EU as well.
So it's fair to say generally that while Canada has been a leader, or at least early to this when it comes to setting a national strategy, when it comes to financing commitments, it's this regulatory component that we're playing catch up on. It seems like C27 is facing a wide variety of criticism, partially due to this component's inclusion. So I'm wondering if you can talk us through some of the components of ADA, and maybe then we'll get to why people are so vocal about its inclusion.
So just to be clear, Bill C-11 died because the election was called. And so it didn't have enough runway to make it through the 3 readings. Bill C-27, when it was first introduced, ADA was the new component of that bill. ADA, what it seeks to do is provide relatively high-level accountability requirements for any artificial intelligence system that falls within a classification of high risk. Now, the challenge with the bill is that it leaves a lot to regulation. So the law itself, if it were to pass as is, doesn't actually define what high impact means, which means the very heart of the bill and the very heart of the law, you wouldn't know what exactly it's applying to. You could certainly, we can guess, even sitting here today, what the government means by high impact AI system. It does define artificial intelligence, and it has a number of other important definitions already contained in the draft, but it doesn't define high impact. So we are very much waiting on further guidance to understand what precisely this law would govern. And that's some of the criticism that has come forward about the bill. So really, if you sort of survey the landscape, there's criticism around the fact that it was introduced with the draft privacy law, that we have been waiting for, almost a decade. There's been discussion for over a decade about reforming and modernizing Canada's privacy laws. So the fact that they were paired together was something that has attracted a lot of criticism. A lot of criticism has been sort of levied against the fact that the bill leaves so much to regulation, and there's a lot of discomfort with that process because you don't have a ton of clarity up front as to what exactly the obligations are and what exactly the bill is covering. We also see a degree of criticism about the substance of the bill, which is in particular the sort of extension of ministerial powers to require an audit of high impact AI systems where the minister feels that there could be either imminent harm for sure, but also where they think the artificial intelligence system could either have biased outputs or cause harm. And both of those are defined terms within the draft law. So the extension of ministerial power has certainly attracted a lot of attention and a lot of criticism, as well as some of the key peculiarities of the bill in terms of how much it covers and who exactly it is regulated by this bill. It covers people who develop, design, and deploy systems. And so really understanding where the accountability lies throughout the life cycle of the AI system is important. And there are still a lot of questions about that.
Yeah, and that's where the rubber really hits the road for my audience, right? And I think talking through this balance, do you think that it's possible for any government right now to lay out detailed and specific legislation to address the ongoing development of AI? The day that we're recording, we're learning news that Microsoft is looking to possibly incorporate ChatGPT into its Bing search engine. ChatGPT has only been part of the public discourse or consciousness for a month and a half. Is it possible for this government or any government to set detailed guardrails for this? And if not, how should they be approaching it? Or how does that reconcile with the fact that the penalties for following these guardrails, which are not clearly defined, seems to be quite harsh?
So yeah, let's unpack that because, is this something that we've seen the government do time and again? I think what's really important is if you look at the privacy law, It's detailed, it's specific, it's been subject to a lot of consultation. The issue with the AIDA is exactly as you identify. You've got a very quick, fast moving, fast developing technology that's complicated, not terribly well understood generally. And so looking to highly prescriptive law that's made in Canada is not going to satisfy anybody's needs. If you sort of go back 5 years, 6 years, the discussion around artificial intelligence was this frustration that we didn't know what the guardrails looked like at all. Even though, from my perspective, from the perspective of many that were knee deep in this space, you could already sort of guess where the law would go. But we didn't have clearly defined guardrails. And we had some policy guidance, but it was very high level. We didn't have much more than that. And that was a frustration, because if you wanted to be competitive using artificial intelligence, but weren't like terribly, didn't have a high risk appetite, then having those guardrails in place in principle would enable you to experiment with AI systems while knowing what you could and couldn't do. Okay. So that was one component that has really changed over the last little while in terms of the discussion. Because today, where we are, is we have prescriptive law on the books in draft form, but being hotly discussed in the EU. And we know that the EU is an important market for Canadians and for Canadian companies. We also see a lot of activity happening in the US with respect to AI regulation, but also AI norms. So NIST, the National Institute of Standards and Technology, they'll be rolling out their AI risk management framework this quarter, and that will be voluntary. It's not law, but it certainly gives clear guidance as to what a responsible AI framework ought to look like. The EU, very different, much more prescriptive, and in fact, there will be specific conformity assessments that must be passed in order to get a particular certification in order to sell into or sell within the EU any high-risk AI system. So you've got these two jurisdictions that are really quite active in their AI regulation, AI policy making, and standard setting. And Canada has also been very active in the policy discussion, but is sort of taking a much more agile approach with the AIDA in saying we will establish these sort of higher level accountability requirements, and we will leave the rest to regulation, which we believe will be easier and faster to adapt as the technology evolves. That we as Canada don't want to put on the books highly prescriptive law because A, we see what these other jurisdictions are doing, and we understand that these are important jurisdictions for our own competitiveness. B, we don't want to create a law that is too different. We don't want to create compliance problems down the line because our law is too different and very prescriptive. But C, we understand that there are significant risks associated with this technology. As much as there are potential amazing benefits, we need to put in place some guardrails to help our industry understand how you safely and responsibly experiment with artificial intelligence and use artificial intelligence in your business. So that's really what you see the government doing in the AIDA. And on the point of the enforcement, so there are definitely areas for clarification. The criminal liability associated with sort of gross violations has to be clarified. The definitions as they match up, when you read them all together, you really have to think about who does this apply to? Who could be criminally liable under this law? The rest of it, if you look at sort of the middle part of the law where it articulates a number of accountability obligations, basically what it says is, if you assess your system to be a high impact AI system, again, we're not entirely sure what that means, but we can sort of guess. If you fall within that category, you have record keeping obligations, you have risk mitigation obligations, you have public disclosure obligations, and where there are reasonable grounds to believe that you're in violation of your obligations or you're at risk of causing harm, there may be an audit of your systems and an audit of your processes. So you have to demonstrate that you have kept appropriate records, you have made appropriate public disclosure, you have mitigate as much risk as possible. So that's really what the heart of ADA is doing. And then it establishes some monetary penalties that are specifically intended to incentivize compliance and disincentivize, obviously, non-compliance. So it specifically says in the draft text right now that these penalties are not meant to be used as punishment. They're really meant to incentivize compliance. That's the heart of the Canadian law. And what's being really hotly discussed is the process by which the law came to be, and then some of those sort of more specific requirements around, what does the process for regulation making look like? And then in the bill itself, some of the text needs to be clarified because, for example, the criminal liability component, which is super important, is not clearly, how it would play out isn't clear. So we need better guidance on what that looks like. Now, I will say one more thing, which is that I think the government has heard loud and clear that there's more guidance that is needed, specifically around high impact systems and what that means. So I anticipate we will see better guidance from the government in the next few weeks. Certainly within this quarter, I would expect to see something so that we can start to debate the substance of the draft law with some specificity, like greater specificity associated with it, as opposed to where we are today, which is focusing mainly on that process of how did ADA get included in this omnibus or multi-part bill? Do they really all belong together, or can we just deal with privacy now that we've been talking about it for so many years, and then we'll get to ADA later?
Hey founders, are you considering building your startup on AWS? From ADA Support to Neo Financial, Canada's top startups build on AWS, but they don't do it alone. So whether you're looking for help solving a technical challenge, hiring the right engineers, or finalizing a fundraising round, AWS has all the resources you need to get started. There's a reason more startups build on AWS than any other provider. AWS is here to help you succeed from inception to IPO. To learn more or to start your cloud journey, go to www.aws.amazon.com/startups. I want to go back to the regulatory component because you've given a pretty charitable approximation of why the Liberal Party is kind of taken this track, where it's in relying upon the regulators to set the specifics. It allows the government to set a broad framework, but continue to be agile in probably a technological space that is changing the most rapidly compared to anything we've ever seen before. Society is fundamentally changing by new product releases by the day with this stuff. That makes sense. I'm also wondering if it's even possible when it comes to the penalties being too harsh, whether they're just supposed to be kind of preventative consideration. If it's even possible, given the inherent nature of AI for these people deploying these systems, to actually report elements of bias or how these systems are being made. Because as I understand it, the technology isn't built to do that. It's a bit of a black box by design. So whether or not the bill is specific enough about what needs to be done and who needs to do it, defining those terms, is it even possible for AI companies, AI systems to really give the information that this bill seems to be asking for?
Your question about can AI even deliver? Can the process of developing and deploying artificial intelligence deliver on the regulatory requirements you see in ADA? That's an important question because it's not specific to Canada. So if you look at different laws in the US, including New York City, that come April 15th, 2023, the obligation to demonstrate a bias assessment of AI systems that are used solely in recruitment and employment purposes, That's already on the books, that you have to be able to demonstrate some bias assessment. There are a lot of questions as to what exactly that looks like and what's the benchmark. And that's where you have international standards organizations and other such organizations working hard to help establish what some of these benchmarks ought to look like. But you have that in laws in the US, and you certainly have that in requirements that we see for selling into the European market for those high risk systems. So again, we're not talking about every AI system. There is discussion in Europe about whether the law ought to cover general purpose or only high risk so far. And I think it will remain that it's high risk in the law, but you've got a certain category of use case of your system that is going to be subject to greater scrutiny. And that greater scrutiny is going to cover 3 distinct phases of the life cycle. The first will be the input stage. So doing an assessment of your data, looking at it from the privacy perspective to ensure that you're using personal information where applicable in accordance with privacy laws, that you're not using personal information to train your systems without having given sufficient notice and to the individual, and without having in place the appropriate sort of legal framework to use that information. So that's number one. And then you move into the actual development of those systems, and we see that there's quite a bit of emphasis in international different laws in different jurisdictions around what kind of verification and validation of your system you need to do if it's a high risk, if it falls within that high risk or high impact category. So you're going to be needing to do that in any event if you want to sell internationally. And then the third is in the ongoing monitoring and in sort of the public notice and disclosure and the relationship with regulators. In the EU, they're talking about, and actually in some countries have already stood up, an AI supervisory authority. They're looking at actively, and again, having started this, actively using sandboxes to test out the regulatory framework to see how onerous it is. So it's not just Canada. Canada is one player in this very, very competitive landscape. And in different jurisdictions, they are already putting these requirements on certain AI systems in certain use cases. We see a lot in healthcare, employment, financial services. That's where you're like some of the key areas where you've got quite a bit of oversight, as you would expect. In the Canadian context, the types of requirements are relatively consistent with other jurisdictions. So the public disclosure is consistent with certain jurisdictions. You can see it in certain laws. The requirements to test for bias and harm, you could see it in some of the laws that are already on the books and that are likely to pass in different jurisdictions. The verification and validation of systems, you can see that as well. The relationship with the regulator, you can certainly see in the European context. Even in the US, various regulators, including the FTC, have come out fairly strong saying, we're going to have our eye on this. If you're operating a high impact, high risk system, we're going to have our eye on what you're doing. This isn't the Wild West anymore. So in that respect, it's really important to understand that this isn't just about Canada. This is about how you establish and develop and deploy systems internationally.
So that's an interesting point, because one of the questions I had that I was going to ask you was whether or not what Canada is trying to do was going to play well internationally, or simply be another situation where through poorly crafted legislation, we push all of our Canadian AI talents. We're a big feeder system to either US or other global entities where they don't have these restrictions. But you're saying that we're actually kind of aligning to what's going on globally, which, if that's the case, let's take it back to then that regulatory component and whether or not Canadian regulators can meet the level we're seeing in the EU and elsewhere.
Absolutely. So I think you've summarized it well. The point is that Canada, in establishing sort of a higher level open law, is in fact enabling itself to align with different jurisdictions. There are flaws in the law for sure. It's not perfect, but you can understand the approach, which is come out with higher level requirements, accountability requirements that generally do align with different jurisdictions, and then you can iterate as the technology and the law evolves. It's not that Canada is trying to follow any particular jurisdiction, but it's putting in place sufficient guardrails to require accountability of high impact systems without having prescriptive, onerous law that's trying to regulate the nitty gritty now, so early on in the sort of the overall life cycle of artificial intelligence. In terms of Canada's, general relationship with regulators and the law, absolutely we need to establish a better dialogue with whomever is going to play this role of the AI and data commissioner. The commissioner right now, as anticipated in the law, is a delegate of the minister, not accountable to Parliament. And again, there are pros and cons of that. But the idea is that you do create, at least attempt to create, a stronger dialogue with whoever is playing this regulatory role. The biggest issue that we have seen is that, the process for developing regulation can be onerous as well. And where you don't agree on some of the key fundamentals up front, then you don't really understand what you're getting into with the draft AIDA. And that's where there's so much discomfort. It really has to get to the heart of, we're not clear on what some of the fundamentals of the law are. They're being left to regulation, but we have no clarity as to how exactly that's going to operate. And we do have examples, Castle, I guess, is one, where we've left so much to regulation and then it just didn't materialize, or it was extremely complicated. The process was not straightforward. This is going to have to be certainly something the government deals with. And this is part of the reason there's so much pushback on the AIDA. It was included with the privacy bills, and there's too much that's sort of left to imagination right now. There isn't enough that's clarified. We need to get to a point where we have greater clarity on some of those fundamentals.
Yeah, I'll say, Castle's a great example. That's something that we deal with as businesses. Most of the businesses that listen to this podcast deal with it as well. It's a minor annoyance. I think for everyday Canadians, a better example would be like, we have a competition commissioner that seems to be in a similar circumstance as the AI and data commissioner would be in, that doesn't have the budget or the teeth to effectively fight on behalf of Canadians for competition. And we have a CRTC that doesn't necessarily believe that like competition is one of its requirements when it's regulating its space. But that's like a whole other podcast. I do want to get back though and maybe close off on this idea of how this bill came to be and what comes next. It's still in its second reading. There's still committee work that needs to be done. There's been a bunch of complaints as to whether or not enough consultation's been done. But I think anytime a federal government lays out any sort of omnibus bill, there's always complaints about competition. I'm interested in that. And I want to frame it in relation to something that Stephen Marsh recently wrote in the Globe and Mail, where he basically said that the government is trying to do to artificial intelligence what it should have done to social media 10 years ago. But these technologies are not alike. They're different cases with different requirements requiring different regulatory frameworks. And we haven't talked too much about the privacy component, which is at the upper level of Bill C-27. So I'm wondering, let's start with whether or not you think ADA should be part of C-27 or its own thing, and where you see it going from here.
ADA, so the discussion right now is whether ADA should be separated from parts 1 and 2 of C-27 and dealt with on its own. There are, I think, practical reasons that should and should not happen, including reasons it should is because it does need significant consultation. I do think we need to iron out some of those components that are unclear or just not available in the current draft. So that, I think, is a really important process before the law is tabled. Reasons it shouldn't are very practical. I mean, if we don't table it now, then the likelihood that there is any meaningful federal AI law in the next few years is probably pretty low. It's not certain, but it's probably pretty low. We're somewhere in between where it very much makes sense to have some law governing high risk or high impact systems, because of the potential harm that can be caused. And we've seen some of the impact of that harm. There have been a number of great articles written about the bias and the sort of unintended consequences of AI that's very damaging to individuals. So we want to regulate against that. But at the same time, we want to create the space for the technology to develop. We want this to happen in a manner that is responsible. At the end of the day, whether there's law or not, responsible AI will require certain assessments, certain oversight, certain accountability within a company. Like our company should be doing this regardless of whether there's law in the books or not. And those different components of what accountability looks like, we know what they are. We see them in the different drafts of different laws around the world, and we see it to an extent at a high level in the AIDA. So there are parts of the AIDA that I really don't object to. You look at the parts that sort of indicate what the general accountability requirements would look like, I don't object to them. What I think we need clarity on is exactly who they apply to, how they're meant to be operationalized, when they're triggered, and then what are the consequences for noncompliance. That's really important, though. I've listed a lot of really important pieces of a law that you would want to have clarified. We'll need to see what comes out in the next few weeks with the hopes that something much clearer comes out, some clearer guidance. But at the same time, there are pieces there of the law that we're going to see regardless of whether it's in this particular law or in a future draft. We're going to see them anyway.
Okay, a lot of wait and see. Let's have you back on the podcast to talk this through when in the coming weeks we get a little bit more detail and we can react to the bill as it is rather than what it might be or what it isn't.
Awesome. Thank you so much. And yes, I would love to be back on.
The BetaKit podcast is produced by BetaKit Incorporated. It's edited by Katie Lohr, and its hosts are Rob Kennedy and me, Douglas Saltis. To learn more about how you can support this podcast, head to patreon.com/BetaKit.